In this video, we're going to go through the SCR Form 310 agreement contract that you'll complete as a home buyer in the state of South Carolina. Hey there, my name is Chris, and I find it helpful to take a few minutes to go over the SC purchase and sale contract before you sign it. That way you know what you're getting into and what some of the different terms and dates mean. Because the last thing you want to do is just tap and e-sign one of these to get it out of the way and then realize something wasn't aligned properly or that your expectations weren't properly managed. Now, quick disclaimer, I'll be giving a brief synopsis of a few of the more important things on this form, so make sure you read it in its entirety and jot down any questions you might have. So with that said, let's hop on the computer and break down some of those important sections. Alright, so starting on the first page here in section 1 of the contract, this is pretty straightforward. You have the buyer's legal name, seller's legal name, and the closing attorney that you, the buyer, selects to coordinate the transaction and closing. This part here will distinguish if the buyer or seller is a South Carolina real estate licensee, also known as an agent, and both the buyer and seller will initial here verifying that they are either a client or customer in the transaction. Now, full breakdown of these are listed on the SC Disclosure of Brokerage Relationships, but basically, a customer is someone who chooses not to establish an agency relationship with the agent, however, can still expect honest and fair dealing and receive limited confidentiality. And a client includes those of a customer, but with full confidentiality and fiduciary responsibilities or duties owed to them by their agent with whom they have an agency relationship agreement with. Here would be the purchase or contract price, which is your offer, and then you'll check how you plan on securing these funds, whether by finance at 100% with a mortgage, a combination of financing and cash, or just 100% cash. You have your pre-approval or proof of funds. You'll attach that with the contract and specify here. Now, an option you also have, if you're waiting on one of these, things are moving pretty quickly, but you want to submit the contract, you can select this to be delivered before and put a date here so the seller knows that you are working on getting these and will get it to them by that date. And this last box here is if the contract is contingent upon the sale and closing of another property the buyer may have, and if you're attaching an SCR 504 form, which is the buyer sale contingency addendum, if so. Section 3 will be the property address, but also explains that the seller will convey and buyer will buy not only the house and land, but also any improvements, landscapes, appurtenant interests, which could also include fences, storage units, in-ground pools, aerial mineral rights, and things like that, unless otherwise specified. Also, that the seller will maintain the property and any personal property conveying in operable condition from the effective date through closing, subject to normal wear and tear. And lastly, that the buyer has an opportunity to inquire about any owners association or common area issues, condo master deed issues, including the bylaws, insurance and financials, and any assigned parking, storage areas, or memberships, etc. prior to signing. And then the property address would be listed here. And this last part at the bottom would be to specify if there is any personal property that's going to convey with the sale. Now, it's good to know what real property or real estate is compared to personal property. Basically, real estate is anything affixed to the property, and personal is anything that's movable. The general rule of thumb is anything that is screwed or glued to the property will remain with the home, and anything that is detached or freestanding will not. So like the refrigerator, washer, dryer, lawnmower, patio furniture, curtains, or TVs, etc. would be considered personal property, whereas things like a shed that's affixed to the ground or curtain rods and TV wall mounts that are mounted to the walls would be considered real property and will convey with the sale unless specified otherwise. If there are personal property items being included, say outside the refrigerator and washer and dryer, which are pretty common items to ask for, it's a good idea to fill out an SCR bill of sale and attach it, which has much more detail and verbiage on there for personal property. So if the sale wasn't to happen, then everything would revert back. Conveyance, closing, and possession lists that the closing will take place by 5 p.m. on your desired date here, and then a fee simple title, which is the highest and least limited ownership type, will be made. However, this is still subject to any recorded easements, reservations, or restrictive covenants, so there could be some allowable limitations put on a fee simple property. It also specifies the seller agrees to provide a general warranty deed, which the attorney will take care of, but basically this is the best deed type as it provides against claims from previous owners and will provide that the deed is free of liens and encumbrances once you're the owner. The buyer's names that the title will be taken in will be listed here. And to clarify, although these are usually the same in most cases, the buyer names in section 1 are those who will be the actual buyers of the property, and here in section 4 is ownership, or who's actually going to be possessing this property. The seller will pay all deed recording fees. However, if purchasing new construction, some builders will have verbiage written in their contract where the buyer will assume these costs, so you'll want to review this in a new construction contract in that case. And lastly, the closing attorney will deliver the preliminary closing statement to the buyer and seller prior to closing for each party and their agent to review. Section 5 will list the total earnest money that the buyer is going to be offering here. And a quick note, in South Carolina, earnest money is not required for a contract to be legal and binding. However, it does make your offer stronger from a seller's perspective. Now, there's no set amount for this, so it should be something you're comfortable with and how strong you want your offer to be. But this is great to discuss with your agent to come up with a competitive amount given the particular situation. If any of this amount was going to be due and payable with the offer, that amount will go here on the second line. Although this is not common, in most situations this will be 0, and then your total amount again will go on this third line, which states that it will be paid by 6 p.m. on such and such date, which is usually within 48 hours of an executed contract. However, if both parties agree the earnest money shall be delayed, then this contract makes that allowable. It is important to make sure though that the money is delivered by this date, because the seller could terminate the contract if it is not. You'll specify how those funds are going to be paid here, which will be a credit to the buyer at closing or dispersed as parties agree, by court order, or by the contract should the closing not take place. And then the closing attorney or escrow agent who is going to hold and disperse the earnest money will be listed here. This bold section outlines some guidelines on how earnest money will be handled if there is a dispute or default of the contract. But you'll want to discuss this line item here with your agent as it pertains to a fee should an interpolator be utilized, as it can vary on the specific situation. Transaction cost starts off with a breakdown of the buyer's and seller's closing costs and what they're each responsible for. If there are any owners associations, transfer fees, or similar fees, who is responsible for covering those will be checked here. And if the buyer is asking for any seller paid closing costs, they'll be listed here. But these are very uncommon in our current market today due to being very competitive. Section 7 is the buyer's representation as it relates to financing. If you're getting a mortgage loan, you check the first is contingent box, or if you're paying cash, you would check the second is not contingent box. If you're getting a mortgage loan, then the loan term you're planning on obtaining will be checked here, and the percentage of your loan amount after any deposit amount will go in this line. This line will be the date that the buyer needs to apply for financing by, and this line will be the date that a responsible final loan approval should be delivered to the seller on the buyer's behalf. If the buyer wants to change their lender during this financing period, they must notify the seller within X amount of calendar days noted here. However, if by doing this will impact the closing date, buyer cannot change lenders without the seller's approval. If the lender declines or fails to approve financing, the buyer will need to notify the seller as soon as possible, and in this case, either party can terminate the contract. And here will be who the lender is, the type of loan being obtained, if there is a finance addendum attached, or any additional financing terms attached. These don't have to be exact, but are your goals or intentions based on your initial pre-approval letter, so this would be subject to change in some instances. Section 8 goes over the repair procedure, due diligence, and as-is process, and is a pretty important section to read through. So this first option here is the repair procedure, and this talks about the 9 systems that are covered under this option, which will fall into 4 specific categories. The first category covers the heating and air conditioning system, electrical system, plumbing system, water supply system, and water waste system. Another category is to make the roof free of leaks. A third one is environmental concerns like mold, lead, or radon. And the fourth one is to make the improvements structurally sound. The repair procedure is to make sure these and only these systems are operable at the time of inspection. Any repair requests under one of these systems are considered seller paid repairs, and anything else would be considered non-seller paid repairs. This first line will be the date when the buyer will deliver all inspections and any requests to the seller by. And this line down here would be the date that the seller will need to respond by and either agree or disagree to make any repairs from the buyer's request. Now, the seller is not obligated to repair anything, but should they decline to repair any requests under these 9 systems, offer a concession in lieu of any repairs, or if they do not respond by this date, then the buyer can technically terminate the contract and not have to pay a termination fee for doing so. The next section is due diligence. Much like in North Carolina, this will be a block of time that starts as soon as the contract is signed by both parties and will run through an expiration date listed here. In this time frame, the buyer can do any inspections or research on the property that they wish, but keep in mind any repair requests that they may have will need to be submitted, negotiated, and agreed upon prior to the expiration date. Getting an extension is possible, but is negotiable between the buyer and seller, and in our current market, getting an extension on this due diligence period is usually unlikely, as sellers feel very confident that their home will sell whether to one buyer or another. Now, during the due diligence period, the buyer can terminate the contract for any reason or no reason at all, and for this right, there will typically be a termination fee listed here to be paid at that moment. In the event the buyer cancels, this helps compensate the seller for lost time. There's no set fee for this, but it could be a few $100s to a few thousand, so it's really something you want to talk with your agent about to determine what's competitive and what you're comfortable with. The big difference between repair procedure and due diligence is the repair procedure does not have a fee, but it's limited to those 9 systems. The due diligence has a fee, but you're not limited at all. And then as is clarifies that the property will be sold as is, which means the buyer is buying the property in its current condition condition for the purchase price, while the seller will maintain it from the effective date through closing, subject to normal wear and tear. The buyer does still retain the right to inspect the property by a date listed here, but is for informational purposes only. The seller is not obligated to remedy any issues the buyer discovers during this time. The buyer may not terminate the contract based on the results of these inspections. The inspection and reinspection rights covers that the sellers will make the property accessible for the buyer and any persons they choose to perform any reasonable and non-destructive inspections of the property with reasonable notice to the seller through the closing date, and the seller will grant the buyer accessibility to do a final walkthrough within 48 hours of closing, as well as keep all utilities on through closing. And then here, if the property you're looking at is vacant or maybe a foreclosure and hasn't had utilities connected for some time, this checkbox will grant the buyer permission to have those utilities connected during the inspections. Section 10 is the appraisal contingency within the contract that goes along with the financing contingency 99% of the time. So if you're obtaining financing, the lender is going to require an appraisal most of the time. And the first box checked will signify that the contract is contingent upon the property being valued according to the appraisal for the purchase price or higher. So if the home is selling for $200,000, it has to appraise for at least $200,000. If the appraisal value comes back less than the purchase price, then the seller has 5 days to reduce the purchase price, or both parties can agree to proceed with the current term, in which case the buyer will need to cover the difference. If the seller refuses to reduce the price and the buyer doesn't want to or can't cover the difference, then they can terminate the contract. And the second box would be if the contract is not contingent upon an appraisal, which is what you'll typically see in a cash deal. Section 11 covers termite inspection report for non-new construction property. The first box will be if the contract is contingent or not contingent upon inspection, if the buyer or seller is having the property inspected at their expense, and if the buyer or seller is selecting who that pest control inspector will be. And then whatever party is covering the inspection checked here again and will deliver notice of the report no later than X amount of days prior to closing chosen by the buyer. And a quick note, if you're a VA buyer in South Carolina, you cannot pay for your own termite inspection. Someone else has to, whether it's the seller or agents, etc. It can't be the VA buyer. If the report reveals the presence or damages by termites, then the seller should remedy and provide a clear infestation report to the buyer no earlier than 30 days prior to closing. However, if the seller does not make any repairs or treatment, the buyer has the option to proceed with the property in its present condition, negotiate with the seller a payment for these repairs, or terminate the contract. It also covers that if the property is a new construction, the seller should certify that it has been treated for the prevention of termites and will provide the buyer this written certification at closing. Section 12 talks about surveys, title examination, elevation, and insurance. It's highly recommended that the buyer gets a survey, especially if you're thinking of adding a fence, landscaping, pool, or things of that nature. So they would really want to get the property surveyed to know exactly where the boundaries lie. And that's even advisable if you don't plan on doing those things. It's also recommended to have the title examined, which the attorney will do, and to get a cost estimate for insurance on the property. You want to verify its existence in a flood zone, which the lender will also do, but your agent can check the FEMA flood map to see if the property is in a flood zone prior to the lender. Section 13 talks about survival clause that covers, say, if there's a repair that needs to be made and was agreed upon prior to closing between both parties, but for whatever reason it cannot be completed prior to the closing date, this repair would survive closing with an amendment to be prepared after the fact. If there was a home warranty being offered or the buyer is requesting one, who is ordering it would be listed here. If it will or will not be provided by closing, checked here. An amount that's going to be paid towards it on this line, who will be paying this amount listed here, and then the name and type of warranty would be listed here. Now the buyer would pay any deficit to this amount listed here, and any surplus would revert to who covered the amount initially. These are uncommon for the sellers to cover in this market today, but the buyers are free to purchase their own home warranty before closing if desired. Section 15 clarifies that the property is damaged by fire or any other casualty prior to closing, both parties have the right to terminate the contract within 5 calendar days after notice if either chooses. Now if neither party chooses to terminate, then they will proceed with the contract, and the seller will be responsible to either repair all the damage, remit an amount to the buyer for repairs, or assign to the buyer the right to all proceeds from insurance. So a residential property condition disclosure statement, also known as a seller's disclosure, is a written form for sellers to convey to buyers about the condition of the property, any known material information, and about the neighborhood or community for which the property is located. This is important to look over and make sure the seller has made no representation of any sort of issues that they know of. Now this does not replace any professional third-party inspections, as these are simply statements made by the seller. This first box will typically be checked to acknowledge that the seller has delivered a copy of this to the buyer prior to the contract. If a property condition disclosure will not be provided, then that will be checked here. This is usually uncommon, but could be the case because there are some exemptions to property owners not having to have a seller's seller's disclosure. For example, if you're buying a foreclosure or an estate or one family member buying from another family member, etc. But again, this is rare. Most times you are going to see a seller's disclosure. Section 17 covers if the property was built prior to 1978, then there will be an addendum disclosure, a lead-based paint, and lead hazards form to review. And buyers should also receive an EPA pamphlet from their agent to read over. Section 19 covers any interest earned from the time of deposit to closing on the buyer's earnest money belongs to the buyer. But if the buyer agrees, the broker may deposit earnest money into an interest-bearing trust account, in which case the broker would retain all interest earned and may contribute some or all to a charitable enterprise. Adjustments basically breaks down that the seller will be responsible for the prorated amount of any taxes, utilities, and insurance, etc. through the settlement date for the seller's portion of what they lived in, and the buyer will be responsible for thereafter. And then the next page really just gets into some of the legalese as far as outlining various terms and things like that. If there are any attachments or recent changes, amendments, contingencies, etc. agreed by the parties that alter any contract language conflicts, then any such documents to be a part of this agreement would be identified or described here. The acknowledgement reiterates that each party is responsible to verify all wire instructions and that they have received, read, review, and understand the various contracts and agreements, and that they also have the opportunity to receive legal counsel prior to signing anything. Every offer has an expiration date, and that will be listed here. When an offer or counteroffer is submitted by one party, it will expire or can be rescinded prior to this date by that party unless it's accepted or countered by the other party first. If either party is utilizing a power of attorney, this will be checked if the supporting documents are attached, or to be delivered will be checked, and the date when those will be delivered by listed here. And then here the buyers will sign a date, and the sellers will do the same just below. Lastly, here will be the buyer's agent's information and the listing agent, also known as the seller's agent's information here. And with most agents you work with, you'll probably be prompted for e-signing blocks through either zip forms or DocuSign, which are e-signing providers to fill these out. So that is the South Carolina contract in a nutshell. If you have any questions or would like to know how I can help you with your home purchase, please reach out and we can talk further. With all that said, we'll wrap this video up. If you enjoyed it, I hope you would give it a like and leave a comment below if you've recently purchased a home in South Carolina and how your experience went. If you're interested in coming along on my journey as a real estate agent or for more videos like this, then I hope you would consider subscribing. Well, let's make every day count, be more than average, and I'll see you in the next video.